We've heard testimony today and some of the conversation that we've already had that FERC may have its own set of guidelines that it follows, while the resource agencies have another set of requirements or rules altogether. So FERC has to look at hydropower relicensing in a multidimensional manner, where some of these resource agencies may look at them one-dimensionally through environmental protection rules without taking into consideration costs or benefits. And so I was curious if in your evaluation of this, does federal law create this conflict and create these two different sets of rules that are looked at by the agencies and FERC?
Well, in my history at FERC, and I started in 1978 and was there till through 2009, originally it was not a problem because FERC interpreted the 4E conditions and the Section 18 conditions as basically advisory. But through a number of court decisions that occurred starting in about 1983, I think, with Escondido, those conditions were made mandatory without FERC having any ability to modify or consider those conditions. What that did for the process, and we had hydropower development through the 80s. We had as many as 500 applications per year for new projects, not the kind of projects that we were hearing about here a minute ago, new projects on rivers prior to 1983. But what happened then was it became apparent that the Commission could not move forward without an agency deciding whether or not elk habitat was critically important for their purposes in imposing those conditions on a hydropower project that had no relationship to elk habitat. That started sort of the unfolding of the hydropower program, and it has just continued through the years to the point now where we essentially, for decades, have had no net development of hydropower in this country, while other forms of generation have continued to grow. Nothing has happened since 2001 when the Commission staff recommended to Congress that we had a problem. Those problems are just as significant today as they were over a decade ago, and we still do not continue to develop the hydropower potential of this country.
So what would your recommendation be?
Pure and simple, those conditions, that distributed decision-making process or dispersed decision-making process has to have the discipline of an agency that is vested with the authority and the responsibility and reviewable by the courts to exercise the laws, the Endangered Species Act and others, and make decisions across the spectrum of issues on what's in the public interest. That does not happen now. It happens in the natural gas industry. The 6 principles I mentioned earlier are all evident in the natural gas industry. That's why we put 1,500 miles of natural gas pipeline in the ground every year. The equivalent of that on hydro just doesn't exist. They only have 2 of the 6 principles covered, and nothing can get done.
Mr. Maish, would you like to weigh in on this topic and your experience that you've had through the process?
Yes, thank you very much. I agree with Mr. Robinson wholeheartedly. The resource agencies don't have the responsibility to balance across diverse interests. And it makes total sense. I mean, the resource agencies have their narrow view of resources that they are charged with protecting, and that's their only view of the world. And the fact that reducing hydro means we can't have as much wind or solar generation added to the, just is not in their purview, and they're not capable, I don't think, of balancing across those lines. And you need someone like FERC who has a central decision-making authority that can take into account diverse environmental as well as economic interests and make a final decision. And we don't have that.
So what do you believe would be the best method of reconciliation between the resource agencies and FERC to come to that decision? Do you believe that FERC needs to have that ability to move forward?
I think that would be the simplest and best solution, yes.
Okay. Thank you. Mr. Chairman, I yield back.